Hello, my name is Arden Siegendorf. What you're about to see is a simulated mediation session of a controversy that typically could be referred to mediation by the Civil Division of the Circuit Court in the state of Florida. The session is based upon an actual case which was recently mediated here at the Tallahassee Mediation Center. The attorneys, Ian Brown and Edgar Booth, the claims representative, Mr. Eric Hoffman, will portray themselves. Doris Peoples will portray the part of the plaintiff. And since the defendant had been excused in the actual case from attending, you will not see that party during the video. The parties here will attempt to portray the emotions and the background which you see in the typical case, and we will also try to demonstrate the arguments, the strategies, and techniques which inhere in the process. Because of time considerations, we have condensed this presentation into 50 minutes, since the actual case took approximately 3 hours. We hope and we trust that this presentation will provide you some useful insights. Welcome. Edgar, good seeing you again.
Arden, nice to see you.
Ian, how are you?
Good to see you, Arden.
Might be a good idea before we start. Would you introduce your client to the folks here?
Sure, be glad to. This is Doris Green. I have been representing her in this accident case. Ms. Green, this is Mr. Hoffman over here,
Hello,
Mr. Booth, who you've met before at your deposition, and this is Mr. Siegendorf, the mediator.
Why don't you introduce your client? Let's make sure everyone is comfortable and they understand why we're here. Ed?
Well, my client is been excused from personal attendance because of some personal problems. Mr. Hoffman is representative of the insurance company.
Well, good. Before we begin, I'd like to tell you my name again is Arden Siegendorf. I've been assigned by the court to assist you this afternoon. Before we begin, I'd like to explain a little bit about mediation. I'd like to tell you a little bit about my role and what ground rules apply. Ian, you're doing this quite regularly here in Tallahassee these days?
Mediation, yeah, we're mediating very frequently.
What are your thoughts about the mediation process?
Well, it's been very successful for us. As you know, most of the judges here in the Second Circuit require it. And I would say that we have a success rate of between 85 and 90% of the cases we mediate. The clients like it because it gives them a lot of input into the final decision as to how the case is going to come out.
How about you, Ed? Have you been keeping any kind of track of your mediation experiences?
Not really, but we found it to be very helpful in reaching a conclusion, which is always the reason you're here.
Okay. Eric, you've been doing some mediation here in town too, haven't you?
Quite a bit, yes.
Okay. I hope you'll be able to help us get this case resolved. I'm going to concentrate a little bit on Doris because she's never been to a conference before, so if I focus on Doris, you'll understand I'm trying to make her comfortable here. We talk about mediation as a process, Doris, which is a neutral party, that's me, attempting to help, encourage, and facilitate the resolution of any dispute, but I don't dictate what that result is. My background includes being a circuit judge in South Florida, and I'm a certified mediator and an attorney. What I will do is try to help you without forcing you to do anything in this case. I have no power to force anyone, but my job or my role is to help you understand the case and what the issues are. I'll talk to Ian some because he's probably already given you his views about the case beforehand, am I right? Mm-hmm. You haven't had a chance to hear what the defendants say. You know, that famous radio commentator says the, quote, rest of the story, end quote. So what we do here at this mediation conference is give your attorney a chance to present your case. I'm going to ask that he do this in a brief, non-adversarial, non-argumentative fashion, if that's possible, Ian. And I would like to know a little bit about the case. The lawyers have given me a summary of the facts, but it's a good idea so that Eric is comfortable that he knows the case from your point of view. Then what I'd like you to do is to listen actively to what the defendants and what Ed Booth and Eric may have to say about the case. They get a chance to give you their thoughts. We'll then take a brief comfort break. I would meet privately with each side. We call that a caucus. And in the caucus, it's my job to help you evaluate the benefits and the risks and the costs of this lawsuit and to suggest possible settlement alternatives. Is that pretty much what Ian explained to you might happen here at this mediation conference?
Yes, it is.
Okay. Do any of you have any questions about the case before we begin? I should go over, since the court has ordered this mediation process, there are a few things which we should chat about. To encourage everyone to participate in this process, we're going to invoke the rule of privilege, which means that anything which is said and done here is not admissible in evidence. That means, Eric, you're free to make offers to the defendants and to the plaintiff, and the plaintiff is not allowed to tell the jury in the event we don't settle this case that you're at fault or anything of that nature. You're free, Doris, to talk about how you feel about this case. In fact, we will encourage you to participate in this conference, unlike the trial, which is very formal and very structured. By the way, since we're talking about settlement, you should be optimistic that we could settle your case. It's my experience that somewhere between 2/3 and 3/4 of all the cases that are mediated settle at or as a result of the mediation process. If you agree to a settlement, the rules of procedure require that we write it out so we have a commitment and so that each side is bound by the agreement. Of course, you're not required to settle. It's only if we reach an agreement. The reason people settle cases, in my opinion, is that a trial like yours could take years to resolve. It costs a lot of money. It's unpleasant. And then finally, it is a highly uncertain outcome. The order and rules also require us to stay at the conference so long as we're making progress towards settlement or until I declare an impasse. And I will consult with each of you, Ed and Ian, before I would declare such a declaration of impasse. There are fees involved in mediation. They're generally shared by the parties. And I have provided each of you before the mediation conference a written disclosure statement going over these ground rules and the fees that apply to mediation. Have I not?
You have.
Yes.
If there are no questions, then Ian, why don't you tell us a little bit about your case?
I'd be glad to, Arden. First of all, you've already met Ms. Green, and we're here today, and I want everyone to know that we're here in good faith to try and get this settled. And with that, let me give you a presentation of what we feel happened at the time of this accident. Ms. Green, who at the time of this accident was 26 years of age, was traveling westbound on US 90 towards Quincy. As she approached the intersection of G, F, and A Drive, road that dead ends into US 90, a vehicle being operated by Philip Morris came out of the intersection where it had a stop sign directly into the path of Miss Green's vehicle. It came out so suddenly that there wasn't an opportunity for Miss Green to take any evasive action. There was a resulting collision, and after the collision, my client found herself trapped in her vehicle. There were some eyewitnesses out there who came up on the accident and approached my client's vehicle. The first person to approach my client's vehicle was an individual by the name of Dick Tracy, a former law enforcement officer who knew my client and knew my client's family, and indicated to my client that she should move over to the passenger side of the vehicle and claim that she was not driving but was a passenger, and that some other individual had been operating the vehicle, and that individual had gotten out of the vehicle and left. My client refused to do that. She was pretty seriously injured. When law enforcement personnel arrived, she was over in the passenger side of the vehicle. What you need to know is this accident happened about 11 o'clock at night. It was dark, and my client was traveling on US 90, a 4-lane highway with the right-of-way. There are some questions that the defense has in this case about whether or not my client had a seatbelt on and whether or not her headlights were functioning. My client would tell you and will tell you here today that she did in fact have a seatbelt on and that her headlights were operational. We are not here to dispute the fact that she was under the influence of alcohol at the time. There's no question that my client had had something to drink. She's freely admitted that on her deposition. And she, in fact, was charged with DUI arising out of this accident and has subsequently pled guilty to that charge. Our position is, however, that the alcohol did not have anything to do with the accident. There was a sudden maneuver by Mr. Morris in failing to stop at the stop sign and pulling directly out in front of my client's vehicle, not giving her an opportunity to take any evasive action.
Were there any eyewitnesses who were not parties to this action?
There were eyewitnesses. The individuals I told you, there was this Dick Tracy, a former law enforcement officer, who tried to persuade my client to not be truthful about what had happened out there, and another individual who approached at the same time. Anyway, that is essentially how we contend the accident happened. My client was seriously injured. She did sustain injuries to her neck, to both knees, and she is currently under the care and treatment of an orthodontist for TMJ syndrome.
What is that, TMJ?
Okay. TMJ syndrome is the joint where the jaw connects essentially to the skull. There was damage done to that as a result of this impact, and it is not moving in the path that it normally should move. This has resulted in severe headaches, pain, the inability to eat certain type of foods, and as a result my client wears a splint, has been prescribed a splint by her treating physician or orthodontist, and that splint is something that she's going to have to use for the rest of her life. My client, as a result of this accident, had the knee problems pretty well cleared up. She still has problems with her neck. It's intermittent pain. It's not as it was at the time of the accident. It has gotten better. The TMJ has been stabilized as long as she uses a splint, but as you will note, this affects her ability to communicate clearly. It kind of gives her a lisping sound as she talks. Okay. The medical bills as we have are $4,935.63.
Yeah, but you've got to understand about these medical bills.
Mr. Booth, I would recommend if you would take some notes, please, about this. It is important to be polite, even though we are informal, and you'll get an opportunity to tell your client's side.
I apologize.
Well, as I was saying, we have almost $5,000 in medical bills. There was $10,000 PIP coverage, and the balance of that was exhausted on the wage loss that my client sustained. She had to leave her position as a packer at Gadsden Tomato. She's now free to return to that work, but was not for a while. And just to summarize, tell you where we're at on the case, we had demanded $50,000, which was the available limits to Philip Morris. The defense has responded by giving us an offer of $10,000. We've obviously rejected that, or we wouldn't be here today.
Okay. Would you mind if I ask Doris a question or two?
Please, feel free.
Doris, tell us how this accident has impacted your life.
I'm in constant pain. I have neurological damage in my neck. I cannot look to my right. I was unemployed for quite some time and incurred numerous medical bills. I've been unable to return to work full-time, and my lower back hurts. I'm just in constant pain, and I'm spending a lot of time from my partial employment. I'm spending a lot of time at the doctor's office, a lot of time from work going to the doctor's.
Okay. How are you feeling today?
I'm okay today. I'm a little drowsy because I'm on medication, but I'm okay.
Okay. All right. I'm going to ask now that you listen carefully to what Edgar has to say and what Eric may have to say about the matter.
Okay.
Thank you. Arden, we see this case much differently, and I think it is important for everybody to understand that the defendants in this case have suffered a very severe loss, as you know, the driver of this vehicle. died not too long ago, and of course his wife is not with us here today for that reason.
The court excused her presence?
Because of his death, yes, sir. So recognizing that accidents do happen and people are injured and the losses occurred, I think it's important for us to understand that both parties have suffered. We don't agree with the conclusions about how the accident occurred. We feel like that the eyewitness testimony is contrary to what has been explained. We have some other evidence which we happy to talk with you in caucus about, but we don't feel like the accident occurred in the way that's been explained. We do feel like the DWI conviction is an indication that Ms. Green was not in control of this vehicle as she should have been. And in addition, the amounts and the kinds of injuries she sustained indicate clearly she did not have a seatbelt on at the time of the accident, and that this other information about the ex-highway patrolman, we have difficulty with that. We'd like to try to settle the case, and that's why we're here, but we do see it differently, and probably our evaluation is going to be much different.
Okay, Eric, on behalf of the insurance company, would you like to say anything?
Just a little something. I just want Miss Green and Ian to know that on behalf of Acme Insurance, we are sorry and we're saddened that this accident did occur and caused the injuries that it did. But as you are aware and as you've heard, there are some factors and issues that we feel need to be taken into consideration. That being the case, we still are here in good faith. We do wish to settle, and we're willing to be persuaded.
In light of the previous discussions and history back and forth of the negotiations, it's my thoughts that we should caucus first with the defendants. Is that agreeable with you?
Yeah, that sounds fine.
Ed, is that all right?
That's fine.
Let's caucus. Ed, as I mentioned at the beginning, and as you know, the role of the mediator is to help you identify issues and to promote communications between the parties and explore some alternatives. How do you all feel that I might best be able to help you go about resolving this particular case?
Well, I'm sorry I interrupted earlier, but Ian knows that all of those medical bills have been paid. And there is no out-of-pocket expense here. And it's important also to take into consideration that there are a lot of things on our side that maybe they don't even know about. First of all, that eyewitness.
Before you get into this, I want to assure you what you tell me is not only privilege that is not admissible, but I will keep it in confidence unless you indicate to me you would like me to convey some of this information.
Well, I feel like you should definitely convey some of the information.
Well, I think so, yeah. I didn't want to get involved with it when we were in general session, but I think it'd be a good idea to make sure at least that, that Ian knows that, number one, the eyewitness that we have interviewed and talked to on a number of occasions indicates clearly that our vehicle came to a stop, that there were no lights on any vehicles coming down the road. Now, I know that Ian is counting on some testimony from the Bureau of Law Enforcement about one of the bulbs on the front of the automobile, but there were 4 lights. He's got 1 bulb. We have a bulb which shows clearly that it was not on at the time it was shattered. And there are 4 lights that are supposed to be on that vehicle. Now, we think at the very least some or all of the lights on the front of the plaintiff's vehicle were not operating.
Correct.
Now, the only thing that the law enforcement people can really say is that at the time of impact, or at the time that this light was damaged, there was an impact. But when? This night? Several nights before? 3 weeks before? So the general condition of the automobile, the other circumstances, we feel are going to persuade the jury that, number one, this man who just left work, getting ready to go back home, had nothing to drink. Everybody agrees is a safe driver, a very somber and sober individual, would not pull out in front of a vehicle if it was visible. And we think the eyewitness testimony and the scientific information that Ian may not know about, indicates strongly that the headlights were not on.
All right,
There's no
very-
other explanation.
Any other factors that you want?
It's a wide open road, there's no obstructions
Right.
Mr. Morris would have had.
Right.
Seeing
And there's
the
no
green
reason why
vehicle.
this eyewitness would be involved. And it's different from this highway patrol. Other thing, there's some pre-existing conditions. The injuries that she's complaining on about her jaw, they would not have occurred if she'd had a seatbelt on. There's no way you're going to hit your jaw and the side of your face into the dashboard of an automobile if you got a seatbelt on. It just would not happen. And then the knee injury also is an indication that she didn't have a seatbelt on. And this thing about somebody told her to slide over to the other side, we simply don't buy.
Okay, well, it might be helpful if we were to analytically look at the jury verdict form that you would use in this case. Would we be using a form verdict that asks questions of the jury?
Surely.
Okay, what, Ed, do you anticipate the first question that would be asked of the jury?
Was there negligence on the part of the defendant?
Which was a legal cause of injury?
The injury, right.
Okay,
And
and
then
the jury's
was-
asked to answer that, yes or no.
Yes
What do
or
you
no.
think is going to happen if we're unable to settle this case? How do you look at that liability question?
From our standpoint,
Right.
I think we have some exposure. The DUI, the scientific evidence, and other things, I think would indicate that the larger percentage of fault should be assigned to the plaintiff in this case.
All right, well, let me suggest, since in terms of looking at it in issues, that we separate the questions. First, was there negligence on the part of your driver? Is there evidence that he went through a stop sign?
Yes.
No, there's evidence that he pulled out in front of someone that was on a favored road.
Okay.
So I guess under that standpoint, you probably could conclude some exposure, 10, maybe 15%, maybe 25,
Okay, as high as 25%.
perhaps. Yeah.
The second question would ask, which will help us define the issues on the verdict form, would be what? Was
Was there
Ms. Green?
negligence on the part of Ms. Green?
And how are you and Eric viewing that issue, Ms. Green's negligence?
I think it's larger than his. If there's 25% assigned to the defendant, I would assume 75% assigned to the plaintiff. Again, the DWI being a large
I
part of it.
personally see a little higher, but
Okay.
Within that range.
yeah.
Then would there be a question, any other threshold questions? Is there a question about permanency in this case, or do you anticipate the last question would be just damages?
Probably just damages, but in the just damage issue will be the failure to wear a seatbelt, which may be part of that 75% that we've been talking about, which certainly has an effect upon what injuries she really received for things other than her failure to exercise due care.
So you're including both the possibility the jury could find that Ms. Green, rather, had no lights on, that her failure to wear a seatbelt were all a part of this analysis
I
as
think
to
so.
her
Drinking.
and the drinking.
Yes.
Mm.
Okay. Where do you see the damage range being in this case in the event that the plaintiff is successful? I know you're an experienced trial lawyer. Help us out here. Give us your thoughts.
Basically, I think it's a soft tissue injury with the exception of the TMJ, and there are a lot of dental problems that pre-existed this accident, and we have reason to believe that the TMJ problem is not as severe as what she suggests.
Well, where do you see a range if the case goes the way you're saying, you're expecting a lower range verdict? Where do you put that
Without-
range?
Yeah.
Well, we have an offer of judgment of $10,000.
But I think the way we arrived at it was we assumed that that was about 25% or less of what we thought the jury would assign as total damages.
Okay, but let's look at it from Eric's point of view. Where do you see the upper end if the jury verdict is not, jury's not sympathetic to your eyewitnesses, or they think that although there was drinking, that the drinking did not contribute to the accident, and that they do think she had a permanent injury, including the TMJ? and an impairment maybe for future abilities. Where do you see the verdict range being?
I don't see it much more than 60, 75 tops without making any apportionment for whatever fault.
You agree, Eric?
I agree, yes.
That might expose the insured, though, to an excess verdict if there was anything over the coverage in the $50,000 mark. Is that correct?
That's one of the things you always have in a case, sure.
All right. Give me, what do you think about getting the case settled, given the fact that we might have exposure at the upper end here, rolling everything together? My suggestion and my analysis of the case is not really critical. It's how you're viewing the case. But I haven't heard anything that makes me violently disagree with what I've heard so far. But I do think if we're to get the case settled, you may need to take a look at the potential for a higher jury verdict. Where is the case going to be tried? Is it in Tallahassee?
Gadsden County.
Gadsden County.
Tell me a little bit about that venue.
From a plaintiff standpoint, it's a good place to try a lawsuit. From a defendant standpoint, it's not.
So one of the concerns might be that it's there rather than in Leon County?
Yes, except that we've got drinking, and we have eyewitnesses from Gadsden County. And this man was employed by an agency of Gadsden County. I think it ought to mitigate. If it was different, it's a factor. It's a factor.
Where do you think Ian is really coming from with his demand, since it was for the full amount of the policy?
Oh, he always comes full amount of coverage. In other words, if we had $1 million worth of coverage, this is $1 million case. He doesn't. I mean, if you don't ask.
Do you have a feel for where he might be thinking about this case?
Oh, I'd say probably 15, 20, 25 in that neighborhood.
Okay. What can you do here about getting the case settled? What I'd like to do is, if you have some other thoughts, I know you filed an offer of judgment. We've talked some, we've analyzed the case, you see where the risks and exposures are. Are you in a position to offer him anything in addition to?
Well, as I told Ian and Ms. Green, it is our intent to settle. We came here in good faith. I do have full authority to settle, and that's our goal today. And of course, we will come off of our offer.
All right. What are your, how much can I take them by way of a settlement proposal?
We could right around 14, possibly 15, increase of 5,000.
What do you
think about it?
Why don't we try this? Take him the information about the eyewitness he doesn't know about this other bulb that he probably doesn't know about, and some of the other things we talked about, and we will tell you that if you feel comfortable in increasing the offer, say by to 14?
14.
You play it by ear. If it looks like something that would help get things moving, fine. If not, you can come back and talk, but so that you'll know, we are willing to move some.
All right, that's fine. Thank you. Would you mind waiting outside
That'd be
and
fine.
ask the plaintiffs if they would come in? Thank you. Doris, how are you doing?
I'm okay.
Okay, good. We have some coffee and soft drinks. If anybody needs, you need to take a little comfort break, or you let me know. I want you to feel comfortable, and we're going to try to get this case resolved. I have some good news and I have some bad news. The defendants have asked me to talk to you a little bit and to tell you, Ian, there's some additional facts that they've developed. And I want to do this by way of conveying this. I don't know the facts other than what they've told me, but they said he thought it would be a good idea if they let you know there's another eyewitness who may not be on the witness list that you've been provided, who says that your client may not have had any lights on. They looked down the road, that they're evaluating the case from a slightly different perspective, and that they've done some testing, and that the testing that they have done indicates that the headlights may not have been on at the time of this accident. Is that some things that you're aware of?
One, I'm aware of all the witnesses. I mean, there better not be anybody not on the witness list that I don't know about, or they're not going to be testifying anyway. But I do know there are 2 witnesses, and I do know that both of those witnesses gave preliminary statements that didn't address any issues related to the headlights. Quite honestly, both of these gentlemen said they didn't see Miss Green's car before the accident. So whether they can testify as to the lights being on or off, they can simply testify, in my opinion, that they didn't see anything. And that's a factor we have to consider, obviously.
Okay, now what you tell me, I'm going to keep in confidence unless you ask me to
Oh,
take back some of these facts.
I understand
But they
that.
asked me to present
I
that to you.
understand that.
How are you seeing the issues in the case? What are the issues for
Okay,
trial?
there is an issue on the headlight. Quite honestly, I think that is probably a weak issue for them, simply because you have to understand where Ms. Green was coming from. This accident, as you know, happened right outside of Quincy, right almost at the city limits, on 90. That's a 4-lane highway there. It is not lighted east of Quincy until you arrive at the city limits, which is just about at the point of impact in this case.
Is there a city light somewhere nearby?
There's a city light right at the intersection of where this collision took place, but to the east of that, where Doris was coming from, there were no lights. And you have to then assume, if you buy the argument that there were no lights on, that she was traveling at 11 o'clock at night in the dark with no headlights, without any secondary lighting on the side of the highway, till she got to the point of the collision.
Doris, do you remember?
Yes, I do. My lights were on.
Now, to address and I don't mind you telling them that either, because I mean, I think that's our logical counter to that argument. They had an engineer go out after this accident and obtain one of the headlights off of the Tornado that was in the accident. And that headlight, they claim, which we have not seen yet, was not operational at the time of this accident based upon the filament, the appearance of the filament. We have someone from FDLE, a neutral witness, not a hired gun, from the criminal investigation of this, who says that that headlight was operational at the time of impact. Now, you know, they were looking into filing criminal charges in addition to the DUI because of the seriousness of injuries sustained by Mr. Morris. My feeling is the state would have brought those charges if they felt that the headlights were not operational.
What about
the police officer at the scene also indicated that there were no defects on the vehicles, either of the vehicles, at the time of this accident.
How are you going to handle the defense as to the seat belt? And then we also have, I presume, an issue about the drinking.
The drinking is one that I don't think we can come around, and I think that one we would just be plain stupid if we didn't acknowledge that that was going to play a factor in what the jury's going to do. I mean, it's on television all the time that the terrible accidents involved with drinking, and I think that's going to be a factor, and that's one that we acknowledge. As far as
help
the
me
seatbelt,
quantify what we're
Okay.
talking about here.
Sure.
What do you think on the liability question that'll be asked of the jury?
I
Was there
think-
negligence on the part of the defendant driver?
I think given, well, absolutely, I think there's going to be some negligence on the part of the defendant driver. First of all, you know, the gentleman died prior to his deposition being taken, so there's not going to be any direct testimony from that driver.
Now, that wasn't as a result of this accident, was it?
To my understanding, that there were serious injuries in this accident, but to my understanding, he had some underlying chronic condition that ultimately led to his demise.
So what you're telling me, just so I understand, let me state again, so if I'm hearing you right, that there is a serious issue and the client is at risk on the first question about who was at fault at the accident.
I don't think, I mean, I think there's going to be a finding of negligence against the defendant.
Could you quantify, if you tried the case 10 times, how often would you
I
get a
think-
verdict on question number 1?
On question number 1, I think 80% of the time we're going to have a finding of negligence. Not 80% negligence, but 80% of the time there's going to be a finding of negligence against the defendant.
All right, how about the second question? Was your client negligent, which contributed to the accident?
I would think that it would probably be an equal ratio. I think that we, just given the fact that there was drinking involved, that there was no evasive action taken, that there were no skid marks prior to impact, that there is going to be some finding of negligence on my client's part, and Doris and I have discussed that. I mean, we believe that that's going to happen.
So you think most juries will find some negligence?
I think there's going to be some finding of negligence. I think we would be less than honest with ourselves if we said differently.
If you were to exclude the most negligence any one jury might attribute to her, and exclude the least amount, say a negligible amount, and average the remainder, what kind of a percentage for our private discussions do you think would come out of that analysis?
25%.
Okay, and where do you see the jury verdict range in this case being if we're unable to get it settled?
As I acknowledged in my opening, I mean, the medical bills have been paid by insurance, so they're going to get a set-off. They're going to get a jury instruction on that. We do have some wage loss that we can argue. We're going to have difficulty going in arguing any loss of earning capacity. It's pretty much a pain and suffering case. I mean, Doris has a splint. She will have that. So I'm figuring somewhere, and looking at the venue, I think it's somewhere probably in the range of 75 to 100 tops.
On the up end?
On the up end. And that's prior to any considerations of any negligence that's going to be attributed to Doris.
All right, how about on the other end, if the case doesn't go as you're expecting? And if Ed is particularly effective that day, what do you think will happen?
On the bottom end,
Right.
I mean, I think probably realistically where they've pegged it, I think that they're smart fellows. I think that's what they offer of judgment was based upon what they felt that they might end up facing.
So maybe a range of 10,000 on the bottom if you get a verdict, and then a 75, 80, or a little bit above if you get a good result.
I think that's a fair range.
Okay, let me tell you what they've done, and let me offer a suggestion, if I might.
Sure.
They've increased their proposal to settle with you to $14,000. Percentage-wise, that's a pretty good move. I know it's not where you want them to be yet, but what I'd like you to do is to confer with Doris a little bit, see if you might not want to take another look at your settlement proposal, since your initial one was for the full policy, and see if it makes sense to get this case resolved, to discount some for the risk, which you told me there's some, could be 20, 25% just at the very first part of the case, who's at fault, and then to discount because of the problems about the possibility a jury could find no headlights or seat belts and the drinking. And my thoughts are, if you would confer with her and give me a counterproposal, I'd be pleased to take that back to the defendants.
All right. Doris, you've heard what we've been talking about here, and you and I have talked about this at great length at my office, and you know the risks involved. You know this is your opportunity to have some input on how this case is going to resolve versus 6 people that we don't know sitting up there deciding it. You've heard their offer of 14. I don't recommend that we consider that offer now. I think that they're going to show some movement off of that, but I think we ought to talk about some reduction, and I would think maybe coming off by about 20% of what we've demanded right now. That would take it in right around 40 right now. Mm-hmm. That gives us an opportunity to see what other movement they're going to make on it. I think realistically, and I don't want any indications that we're going to go lower than that, but I think realistically we need to consider somewhere around $30,000 as being the point where we talk about walking in this case. What are your feelings on that? And if you have any questions for Mr. Ziegendorf, feel free to ask him for his advice too. He's done a lot more of these than I have.
What was our original offer?
We had demanded 50, as you know, and their response before this today had been 10, and now Mr. Ziegendorf is telling us they're at 14.
I'm not certain. I mean, I don't think that they're taking into consideration that I can't do some of the things that I used to do. I can't swim, I can't bowl, I can't play with my kids. I mean, I was my daughter's softball coach, and I can't do that anymore. And my medical bills are still, I mean, I still have to go to the doctor. I just, 14 is quite low.
It is, and I don't think, as I said, I don't think that's where they're going to stop. And I don't think that we should cave at this point, but I do think we need to show that we're willing to move too. We've been pretty candid with Mr. Ziegendorf so far. You know and I know that we have to acknowledge the fact that you have a DUI conviction from this, that drinking was involved. And like it or not, the jury is going to hear about that, and that is going to be a consideration for them in resolving this dispute. And at this point, you know, you have some say-so and I have some say-so. Once we turn it over to that jury, we give up our right to say what the case is worth. So my suggestion is we go back at this time with $40,000 to show that we're acknowledging that we do have some risks in the case, but that we're not satisfied with the movement they've made on it.
Do I have your permission to do that?
Yes, that's fine.
All right, thank you. Ian and Ms. Green, appreciated your increasing your settlement proposal. I did, as you requested, discuss the eyewitness and the testing. They do recognize some problems in the case, but they do feel, and they've asked me to tell you, that they think the accident still was largely the fault of your clients. They are willing to compromise and have dropped their demand down to $40,000.
Well, we talked some while you all were caucusing. We'd like to resolve the case. Eric's authorized an increase in our offer. We want to make sure that it is conveyed. One of the things I didn't talk to you about, a deposition was taken of Mr. Morris in the criminal case. We've located and had transcribed that deposition. It is available. It is admissible. He says there were no vehicles coming. There were no lights. They have not talked to the witness in any detail. I don't know whether he's going just on the interviews that were made before, but we've talked to the witness again. There were no lights on the green vehicle. But we're willing to try to settle it rather than go back and forth a number of times. We're willing to get into the $20,000 range and see if we can get it settled. I will tell you that Ms. Morris is very upset with the medical expense that her husband incurred and the fact that he did die as a result of injuries sustained in this accident. I don't know whether anybody's thought about that or not, but that's one of the points.
Were there any conditions of the probation that may impact this particular
I believe there was.
case?
Yeah.
Because it's part of my job as a mediator to explore with you alternatives, and if there's anything else that might impact our ability to settle this case, we should discuss it right now.
I've talked to Ms. Morris about that. Her husband died, and she is very upset about it, but she realizes that it isn't going to change anything. She
What
might
did
be
the judge say? What did he order? In the probation?
$20,000 as a condition of probation medical expense.
To be paid by Ms. Green?
Yes, yes,
Reimbursement.
as a result of the conviction of DWI, one of the conditions of probation, and that could be a big factor in this. It might be something worthwhile discussing. We might be able to do something
Could you,
about it.
while I caucus with the plaintiff,
See if I can reach her.
see if you can reach her
Sure.
and see, perhaps to put this matter at rest, if that's something that
Yeah, I
could
know.
be waived.
I don't guarantee anything, but I could try, sure.
What else did you tell me? Didn't you tell me there was some other insurance? Is there a,
We had some med pay that might arguably be available.
she did say she had some unpaid medical expenses, am I right?
Well, you see, one of the things that's a little bit interesting is that Acme Insurance Company had the coverage on Miss Green's vehicle as well as on Mr. Morris's vehicle. So
Well, that's
there might be a little.
unusual.
It is.
Mhm,
It
yes.
is. But then we have to keep the things separated. But we might have a little bit of leeway on some of those other coverages.
Okay. Is that something you might be able to explore, Eric, while I'm meeting with?
Sure,
the
yeah, I
plaintiff?
can make some inquiries on that.
That's
Get back
outside
on
the
that.
liability coverage, but it might
Right.
be something we could do.
Very good. Well, then I'd like, with your permission, to discuss these matters in a final caucus with the plaintiffs.
Fine.
Doris, Ian, the defendants are really anxious, if you are willing to show some compromise, for them to compromise this claim. They have made an increase in their settlement proposal from $14,000 to $20,000. What they've asked you to take into consideration are some of the things we have already discussed, which are some of the risks and some of the costs. We haven't talked much about that. What do you estimate it would take to present this case to a jury, Ian?
So far, we're probably somewhere around $2,500 in costs, so double that, I would think.
But you had indicated you'll have an accident, you may have an accident reconstruction expert.
Yeah, well, there's definitely got to be someone to address the issue of whether the headlights were on.
And so that kind of, or at least an engineer for that. It is an
Yes.
expensive case. You may or may not get your costs back depending on how the case goes. I know it's not exactly what you want, but I'd ask you to take into consideration these factors. And in addition, what I wanted to know, was your client placed on probation?
Yes.
All right.
Yeah.
I understand, and I've been told that it's all right to discuss this with you, that there was a term of condition where Doris had to repay the widow for some of the outstanding medical expenses. Is that correct?
That's my understanding. I did not represent Doris on the DUI, but it's my understanding as a condition of probation, there was roughly $20,000 that had to be paid back.
Okay. Has any of that been paid so far?
No.
Well, what if, as a part of this settlement, we could persuade the widow to waive or go back to the judge and say that she'd be agreeable to waive your having to repay that if we're able to get this case resolved. And of course, the proposal to settle is $20,000.
That's a good point. I mean, we've discussed that in the past. You heard us before when we talked about the time for us to walk on this. We're willing to show some movement too. You heard us before. We said we'd come down to 30 on it. I think if you go back and tell them we'll do it for the 30, conditioned upon a waiver by Mrs. Morris on the $20,000 that is due on the probation, that would require her cooperation by getting in touch with the probation department. But that is acceptable to us, and I don't think we need to really spend much more time on it.
Okay, and tell me about are there some unpaid medical expenses? If so, how much would they be?
The unpaid medical expenses right now are fairly minimal. They're somewhere less than $1,000, but she is still in treatment with her orthodontist. That's projected to be somewhere around $2,000.
She may have some more some
Orthodontic work?
orthodontic work.
Yes.
All right. What I'd like to suggest, with your approval, is that we all get back together in a general session. We are close. We have not yet resolved it, but perhaps by sitting and reasoning together, we can close this gap and get the case resolved.
That sounds good to us.
Okay.
Well, I'm pleased that what started out as a wide gulf has now been closed. We're within a few $1,000s of each other, Ian and Ed. If I have been authorized by the plaintiffs to say if you could come to a $30,000 number, we could settle the case, and I understand there's a $20,000 proposal on the table. In addition, there may be some other things you're able to help us with here towards getting the case settled, and with your permission, I've discussed those with Ian. So let me ask, first of all, were you able to reach the widow in this case?
I was, and I talked with her some. I anticipate she might be willing to compromise the issue of the medical expense. I can't at this time represent that she would compromise the entire amount, and I can't really give you a specific number that she'd be willing to go to. She feels like it should be up to the courts. And since they imposed the probation, that she would be willing to go to the probation people and indicate a willingness to compromise, but the final decision should be made by them, not her.
Okay, but she is willing to go and ask the judge to modify that term?
She's willing to tell the judge that she would not oppose.
She would not oppose.
And then it would be up to the judge to decide what probation conditions
I
he
think
wanted
as a
relaxed.
practical matter, the court's going to do what she wants to do on this. All other conditions of probation have been met, so I feel comfortable with that and the representation Ed's making about that.
Okay.
That gets us closer to, that resolves one of the problems anyway.
All right.
And we have verified that under the other coverage that was on Ms. Green's automobile, there is an additional $5,000 of medical pay insurance, which evidently no one has ever made an application for. And that's still open, it's still available. If they make an application, it would be considered like any other. I don't know what their outstanding medical bills are.
Well, let me say, could we, by way of a final effort here at compromising, accept their offer to go to the judge to assist your client on the probation conditions, which could be anywhere from whatever the judge is
Whatever the
willing to
judge
do.
says.
Could be as much as a $20,000 waiver of those medical reimbursements, and allow you to pick up your unpaid past medicals and to claim if she needs the TMJ treatment. That would add considerably to the ultimate value of the case. And then could we compromise this case perhaps by meeting in the middle, and if they would accept this sum, would you pay $25,000 to accept and settle the case?
Yes, I would. We would be willing to go ahead and meet halfway at $25,000 if those conditions are met.
Ian?
Same with us, if those conditions are met. I mean, that's the biggest fear that we have. But we're willing to swallow our pride and compromise at that. We realize it's going to cost us more to get this to trial than that. So,
Doris, are you in agreement?
Yes. Yes, I am.
Well, what I'd ask, I have here a proposed settlement form which has in the past been satisfactory to the parties. And by way of a close to this mediation session, we should take just a minute or two to go over this form. We do have two special conditions that may need to be added on the page 2. And so by way of closing, the plaintiff, Doris Green, and the defendant, Philip Morris, I'm filling this in as we go
Actually,
along.
that's the estate of, but that's all right.
Okay, it would actually be the estate of Philip Morris, and you'll tell me the name of the personal representative. I'll have that filled in.
All right.
And their insurer, it's Acme Insurance Company.
Yes.
right.
Hereby agree to settle all claims and causes of action and so forth in exchange for the payment of $25,000. Eric, about how long will that be from settlement date for the funds?
I'll be giving Mr. Booth the check today, the draft today.
All right, so then there'll be some other documents. Let's go to paragraph 2. When the money is paid and the release document signed, the form indicates that this case would be dismissed with prejudice, Doris. That means it could not be refiled. Is that agreeable and understandable to you?
Yes.
And I'll prepare that document.
All right, paragraph 3 then says that the plaintiff agrees to be responsible if there are any medical bills or unpaid expenses growing out of this accident, with the exception of what we're going to add, the med pay provisions, because in the unusual circumstances here, Acme is also a carrier on that policy.
That's correct.
Paragraph 4 indicates that the plaintiff will agree to sign the release documents. They're customarily prepared by Acme, and you all have done business in the past? That won't be a
Correct.
problem.
No.
No problem.
Paragraph 5 indicates each party would agree to bear its own costs and fees. And that's understood out of the $25,000. Doris, you'll be responsible for those costs and attorney's fees.
Okay.
You understand?
Mhm.
If you could help us with the special conditions regarding the probation, Ed, that was what?
We agree to cooperate and not voice any objection in a reduction of the probation conditions and abide by whatever the court decides. And also, we agree that we have an open amount of medical pay coverage, $5,000, that they can make an application for, be treated as though it was open coverage.
And that would be cover any unpaid medicals
Up to the limit.
up to the
Correct.
limits.
Under the no-fault coverages of her policy.
That's
I'd like-
our understanding.
I'd like to thank each of you for coming. I hope this mediation conference has been a rewarding experience, and I appreciate your working so hard with me to get this case resolved.
Thank
Thank
you.
you.